Hello, everyone. Jax West from Stephen Avery Project, Justice with Jax, and MAM Gossip. Hold on a second as I'm putting on Stephen Avery Project. Got the filing and live now on YouTube here. Let me post that link. So I just got emailed the filing. I was supposed to go out this evening and I've bailed on it so I can go live. Otherwise, I would have been driving to Chicago right now. So here I am sharing it to Gossip and the Stephen Avery Project group. All right. I'll worry about the rest later. They don't need to be there. Hey, Raquel. So I literally just got it. And here we go. And it is 46 pages. Ready? Mr. Avery's reply to the state's response opposing a motion for an evidentiary hearing and post conviction relief under Wisconsin Statute 974.06. Welcome back, Egypt Mania. Defendant Stephen Avery, by his undersigned attorneys, Kathleen T. Zellner and Associates and Stephen G. Richards, for his reply to the state's response in opposition to his motion for an evidentiary hearing and post-conviction relief, states as follows. Hello, hello, Mary. Introduction. The state has presented an argument designed to, oh my God, with the big words, obfuscate. Obfuscate? I hope I said that right. The significance of Mr. Avery's powerful new evidence that Bobby Dassey had the, and now this word is italicized, opportunity and is italicized again, directly connected to actually murdering Teresa Halbach and to planting the forensic evidence to frame Mr. Avery because he was observed pushing her vehicle, which contained her blood splattered in the rear cargo area and door, onto the Avery salvage yard in the middle of the night, planting it where it would easily be discovered the next day. The RAV4 contained evidence of the violence inflicted on Ms. Halbach, her clothing, and personal effects, blood, and the forensic evidence that was used to convict Bobby's uncle, Mr. Avery, of Ms. Halbach's murder. If whose website is down? Are you talking about the Stephen Avery Project website? I'm not sure if I kept that up or not. Okay. Next page. Bobby's possession of the RAV4 with Ms. Halbach's blood spattered inside of it demonstrates he not only had a direct connection and opportunity to murder Ms. Halbach, but also to plant the following evidence contained in the vehicle. Ms. Halbach's 3 electronic devices that were burned and placed in Mr. Avery's burn barrel. The RAV4 license plate that was removed and hidden in a salvage car. Mr. Avery's blood that was found carefully dripped in the front seat of the RAV4 and applied to the dash with an applicator. The RAV4 key that was found in Mr. Avery's bedroom with his, but not Miss Halbach's DNA. And Ms. Halbach's DNA that was found on the bullet in Mr. Avery's garage. Additionally, if Bobby is the perpetrator of Ms. Halbach's murder, he had the opportunity to burn her body in the Dassey burn barrel, where some of her larger bones were found with cut marks, smelling of a flammable liquid, and plant the remaining bones and burned gene rivets in Mr. Avery's burn pit. In regard to the hood latch DNA swab, Mr. Avery has previously argued that his DNA was removed by nurse Faye L. Fritsch at the Aurora Medical Center on November 9, 2005. upon the request of investigators Fossbender and Wiegert when he was arrested for unlawful possession of a firearm and his body was illegally swabbed. Um, and then there's a footnote on that says on April 4, 2006, Deputy Hawkins signed the hood latch swab over to investigator Wiegert for transport to the WSCL in Madison. When investigator Wiegert arrived at WSCL, he, and I got to scroll down to the next page for the rest of the footnote, presented Wisconsin Department of Justice evidence transmittal form label, blah, 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 blah. Deputy Hawkins' name was typed on the form as a submitting officer, which he was not. Hold on a second. Because we just went over this yesterday, and I have it. It's one of the items that I was looking at yesterday. Can I find it offhand or no? I didn't put anything away. This form that I have, sorry, I don't have all the fancy things, is the evidence release laboratory case to sheriff's office, signed by Sue Gitchell, is who released it on September 25th, 2003. And then Detective Remiker is who received it on 10/13/03. And that's the one sealed envelope containing questioned hairs, one heat sealed plastic bag containing pubic hair combings, one heat sealed plastic bag containing a pubic hair sample, one heat sealed plastic bag containing standard hair sample, one heat sealed plastic bag containing fingernail scrapings, one sealed envelope containing questioned hairs, one sealed plastic bag containing standard hair sample collected by Stephen Avery, one sealed envelope containing buccal swab standard reportedly recovered from Stephen Avery. So I have that. Okay. Back to her footnote here. Then investigator Wiegert handprinted Deputy Hawkins' name on the form, again deliberately misidentifying Deputy Hawkins as the submitting officer, which was a complete misrepresentation. Clearly, investigator Wiegert switched the groin and hood latch swab and fabricated the chain of custody documentation so that it would appear that Deputy Hawkins submitted the actual hood latch swab to WSCL. All right, so back up here. The investigators admitted in the report that they, quote, utilized a Woods light to illuminate any secretions on Stephen's body. Fritsch subsequently took 2 swabs in Stephen's groin area. After that, she continued and was going to take some more swabs when Special Agent Fossbender and Wiegert conferred and determined that the search warrant did not call for that type of exam, unquote. Mr. Avery has previously argued and presented evidence that one of the 2 swabs was kept and deceptively submitted to the Wisconsin State Crime Lab by investigator Wiegert as the RAV4 hood latch swab, which contained Mr. Avery's DNA. So just switcheroo. And hello, Merman. I gotta go through this where they're listing the pages that it was on before. Mr. Avery's trace expert, Dr. Christopher Palaniuk, opined after conducting a series of experiments that the alleged hood latch swab never swabbed a hood latch. The state argued at trial that Mr. Avery's DNA was deposited on the hood latch when he opened the hood with sweaty hands to disconnect the battery to prevent the vehicle alarm from being activated. The state's theory is implausible at best. Mr. Avery's fingerprints were not found anywhere on the RAV4, even though the state fingerprint expert found eight latent prints on the vehicle and testified that someone with sweaty hands was more likely to leave prints than someone with dry hands. The killer had Ms. Halbach's key, so the chances of triggering the alarm were remote at best, and even if that had occurred, the alarm could have been quickly disabled by using the key. Mr. Avery's new witness, Thomas Sawinski, provides the plausible answer as to why the battery was disconnected when he describes the RAV4 lights being off when he observed Bobby and another individual pushing the vehicle onto the Avery salvage yard. Clearly, the obvious and simple explanation for the battery being disconnected was to disable the vehicle's interior and exterior lights so that Bobby and his unidentified companion could push the vehicle onto the Avery salvage yard and avoid detection. Mr. Avery never deposited his DNA on the RAV4 hood latch. The state never explains why Mr. Avery's DNA is not found in the vehicle, but is found on the hood latch, or why his blood is not found on the hood latch, but is found in the vehicle. Of course, his fingerprints are found nowhere on the exterior or interior of the vehicle. Bobby, by his possession of the RAV4, is directly connected to both Ms. Halbach's murder and to framing Mr. Avery. Bobby's possession of Ms. Halbach's vehicle gave him the opportunity to murder her and plant the forensic evidence used to frame Mr. Avery. And then here's applicable case law. We're not reading through that. Argument. Mr. Avery has pled sufficient facts to meet the prongs of the Denny test. The appellate court found that Mr. Avery's new evidence could establish a, quote, direct connection, unquote, between Bobby and the murder of Ms. Halbach, making him a viable Denny suspect. Specifically, the appellate court stated, quote, as discussed below, we are not addressing Avery's most recent filing to this court, which seeks to directly connect Dassey to Halbach's murder. If Avery wishes to raise that claim, he will need to bring a new Wisconsin motion. That motion would need to survive both Escalona Naranjo scrutiny and be found to have merit, in which case the evidence presented might supply the missing direct connection. In that event, the Veli CD evidence might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. We express no opinion on the merit of any such motion, as all such issues would be for the circuit court to decide in the first instance. Unquote. Next section's titled The State's Motive Argument. The state devotes 36%, 14 of 38 pages, of its entire argument to motive, which is the least important of the three prongs of Denny in this case, because of Mr. Avery's new evidence of the direct connection of Bobby to the actual commission of the murder and planting of evidence to frame Mr. Avery. Another 15% of the state's argument, 6 of 38 pages, is devoted to the opportunity prong. A mere 65%, I should move over some. I don't know why this thing always slides over here, but it's like I'm trying to read the screen over here and now I'm just falling off this thing again. I need to move the floor mat. Okay. Sorry. Squirrel. A mere 6.5%. I say the word squirrel and my dogs start barking. That's so funny. A mere 6.5%, 2.5 pages of 38 pages, is devoted to Mr. Avery's powerful new evidence of Bobby's direct connection to Ms. Halbach's murder and planting forensic evidence to frame Mr. Avery. As stated in the introduction, the state's allocation evidence is a deliberate strategy to distract, mislead, and here's that big word again, obfuscate The fact that an evidentiary hearing must be held because Mr. Avery has overcome the procedural bars and met the specificity requirements to proceed to a hearing on his new evidence and Brady violations. As part of its obfuscation strategy, the state attempts to impose an impossible burden on Mr. Avery, not required by Wisconsin case law, to prove with substantial certainty that Bobby had the motive to murder Ms. Halbach. Because motive is never an element of any crime, the state never needs to prove motive. Relevant evidence of motive is generally admissible, and now this is italicized, regardless of weight. The same applies to evidence of a third party's motive. The defendant is not required to prove motive. Evidence of motive that would be admissible against a third party, were that third party the defendant, is therefore admissible when offered by a defendant in conjunction with the evidence of that third party's opportunity and direct connection. Here, Mr. Avery has offered his motive evidence in conjunction with evidence of Bobby's opportunity and direct connection to Ms. Halbach's murder and the framing of Mr. Avery. Mr. Avery's motive evidence is relevant regardless of the weight assigned to it by this court. The state does not dispute that viewing violent pornography could establish motive for a murder. Rather, the state claims that the Dassey pornography of young females being tortured, mutilated, and otherwise abused is simply too mundane, too vanilla, too boring to predispose someone to commit a murder. The state opines as an expert, without having a real expert, on violent pornography that these searches for images of abused and deceased young females are simply too dull for generic concern. Thank you, Egypt Mania. Funny Merman. There's a footnote there that says, according to Wisconsin statute, blah, blah, each image of child pornography can be punished as a separate count of possession of child pornography and can be punished by up to 25 years per charge. Yet they know Bobby had these on his computer and he's never been charged with them. Let's go back. We learned something new today. The state, in an effort to divert attention from the powerful new evidence of opportunity and a direct connection of Bobby to the murder of Ms. Halbach and planting of evidence, claims that Mr. Avery has failed to prove motive by failing to identify with substantial certainty the individual who performed these thousands of pornographic searches on the Dassey computer, as if the burden of proof requires Mr. Avery to produce a videotape of Bobby performing these searches. The state is imposing a burden of proof for motive that does not exist in Wisconsin law. The issue is whether the pornographic searches on the Dassey computer are, and now this is italicized, relevant to motive, and now italicized again, regardless of the weight of the motive evidence. The state's strategy fails to consider that a new witness has established opportunity. Oh, I didn't bring my phone up here. Now I'm getting text messages. And a direct connection between Bobby and the murder of Ms. Halbach and the framing of Mr. Avery. As the appellate court found, if the new connection evidence survives scrutiny, the motive evidence found in the Veli CD, quote, might become relevant, italicized, relevant to showing Dassey's motive, and might bear on whether Dassey is or should have been a viable Denny suspect, unquote. Hi, Donna and Mary. The state wants the court to believe that because some of the computer searches could be done by someone else, Mr. Avery's Denny argument fails. What the state conveniently overlooks is that no one else from the Dassey household has been identified as having possession of Ms. Halbach's vehicle after her disappearance. My dogs are driving me crazy, barking their heads off. Sorry. Mr. Avery's motive evidence must be evaluated in light of his powerful new evidence of direct connection and opportunity for Bobby to be the perpetrator of this crime and the one who framed Mr. Avery. Quote, no bright lines can be drawn as to what constitutes a third party's direct connection to a crime. Rather, circuit courts must assess the proffered evidence in conjunction with all other evidence to determine whether, under the totality of the circumstances, the evidence suggests that a third party perpetrator actually committed is underlined, actually committed the crime, unquote. Sounds like my husband just pulled in. This would be too early for him to come home, but additionally, in its response, the state ignores well-established Wisconsin case law that the court must is italicized, must assume the facts in the pleading to be true when determining the legal sufficiency of the pleading. At this juncture, the court must, did I just read that? No. It just must is italicized again. Must assume that Bobby was the primary user of the computer, as his brother Blaine has attested in his affidavit. And therefore, it is highly likely that Bobby was conducting the searches for pornography. Also, Bobby has been caught in a blatant lie about the location of the computer. He told the police the computer was located in the living room, when the crime scene footage showed the computer was located in his bedroom. Thanks, Donna. Regardless of the dates and times of the searches, and okay, and Donna reminds me, I have to tell people, make sure you like and subscribe. Okay, back to what we all care about. Regardless of the dates and times of the searches, Bobby cannot be ruled out by the state as the individual who was conducting any of the searches for pornography, and his motive must be evaluated in light of his possession of Ms. Halbach's vehicle, which establishes his direct connection and opportunity to commit the actual murder of Ms. Halbach and to plant the forensic evidence used to frame Mr. Avery. The appellate court correctly noted that Mr. Avery cannot definitively prove Bobby's schedule by relying on the affidavits of his computer expert Gary Hunt. Mr. Avery has added additional evidence, including the affidavit of Blaine Dassey and police interviews regarding the family member schedules. Importantly, the motive evidence has to be reevaluated in light of the new evidence of the direct connection and opportunity of Bobby to have actually committed the murder and planted evidence against Mr. Avery. The appellate court did not consider this new evidence, ruling as follows, quote, this is instead a distinct issue that the circuit court should resolve on a standalone basis through a new Wisconsin motion, unquote. Yay, Bryce. I hope you're feeling all right. Next section is titled Pornography Searches Were Relevant in the Investigation of Ms. Halbach's Murder. The state claims in its response that, quote, Avery's contention that law enforcement considered pornography as evidence of motive is false, unquote. The hypocrisy of the state's argument is vividly illustrated by the fact that on March 10, 2006, the state filed an amended information against Mr. Avery, adding the charge of sexual assault, among others. There's a footnote that says almost a year later, on February 2, 2007, the state filed a second amended information dropping the charge of sexual assault. Back up. This amended charge was the result of Brendan Dassey's confession. I don't like it. I know that's what she's doing. Good. I'm glad, Bryce. But it's alleged confession or coerced confession is what it should say. It's not a real confession. Okay. Confession on March 1, 2006. The only plausible reason that law enforcement spent substantial time after the April 21 of 2006 seizure of the Dassey computer, collecting and analyzing the pornography on the computer, was to corroborate Brendan's confession by establishing a sexual assault motive for Ms. Halbach's murder. The state's electronic data investigator, Detective Veely, created word searches relevant to the murder and attempted to connect these specific words to the contents of the Dassey computer. Significantly, Mr. Avery's trailer and his computer was also searched extensively for pornography, and none was found. Detective Veely was asked to generate a report of Mr. Avery's computer. Based on Detective Veely's report, no apparent searches of pornographic and or sexual images were made, and no websites with apparent sexual and or pornographic images were accessed. The clear working theory of the investigators was that the murder of Ms. Halbach was motivated by a sexual assault as described in Brendan's confession. Other motives were ruled out, such as robbery or animus against Ms. Halbach, who had no known enemies. In Judge Willis's January 25, 2010 order denying Mr. Avery post-conviction relief, Judge Willis explained that, quote, while neither the state nor the defense was able to offer any direct evidence of motive for Stephen Avery or anyone else to have wanted to murder Teresa Halbach, it is not fair to say that either party regarded her murder as a motiveless crime, unquote. Clearly, there was a motive for Ms. Halbach's murder. Hey, sexy girlfriend. I'm assuming that's you as anonymous. Sexy assault is a frequent motive in the murder of young women. There is a clearly established, yay, it's you. Um, there is a clearly established correlation between compulsively and obsessively viewing pornography and sexual assault. Mr. Avery's expert on sexual homicide, Ann Burgess, PhD, opines in her affidavit, relying upon 30 years of empirical research, that there is a well established causal connection between pornography consumption and violent behaviors. And that footnote says, oh, hi, Carrie. Um, Dr. Burgess notes in paragraph 15 of her affidavit that not only did the examination of the Dassey computer reveal significant searches for teenage child pornography, but also contains conversations between Bobby and 14 and 15-year-old girls, which have explicit sexual content. He was 19 at the time, right? Oh, footnote continues on the next page saying, in a conversation, Bobby asked the girls to flash him using a webcam. Yuck. Um, okay, now I got to go back up from where the footnote was. Okay. Mm-mm-mm. And hello, Donna. Okay. In paragraph 51 of Mr. Avery's third motion for post-conviction relief, Mr. Avery supports his argument with Dr. Burgess's opinion. The state, in its response, completely ignores and or overlooks the expert opinion of Dr. Burgess, who provided expert deposition testimony in a Wisconsin premise liability sexual assault case. The state ignores Dr. Burgess's qualifications and publications. Dr. Burgess has been qualified as an expert in the areas of child pornography, crime classification, offender typology, rape victims, rape trauma, and serial offenders. She has published extensively, including co-authoring 24 books, 30 book chapters, and over 164 peer-reviewed articles. She has co-authored the book Sexual Homicide: Patterns and Motivations, the Crime Classification Manual, Understanding Violence Against Women, Violence Through a Forensic Lens, and Forensic Science Lab Manual, co-authored with two FBI agents, John Douglas is a very famous name, and Robert Ressler. Yeah, I hadn't heard that before either. Hello, Elisalivids. Because the state charged Mr. Avery with sexual assault on March 10, 2006, the Dassey computer was seized by law enforcement on April 21, 2006. Law enforcement made great efforts to extract all the pornography from the Dassey computer and even went so far as to have Detective Veely conduct specific word searches. Now, this is italicized, related to the murder in an effort to connect the pornography to the murder. The Veli CD contains the state's recovered pornography images relevant and material to the Halbach murder. On the CD, Detective Veely refined 14,099 images on the 7 DVDs and recovered 1,625 violent pornography images. Now, this is italicized, that had been deleted. Footnote says the CD containing Detective Veely's report and unique word searches was withheld from Mr. Avery's defense counsel. The CD contains thousands of images of violent pornography, criteria, word searches, registry, internet history, Windows history, and all MSN messages, all of which revealed a propensity for sexual violence. There were 2,632 word searches performed by Detective Veely of words that he believed were, this is italicized, directly related to the crime, including blood, 1 result, body, 2,083, bondage, 3, bullet, 10, cement, 23, DNA, 3, fire, 51, gas, 50, gun, 75, handcuff, 2, journal, 106, RAV, 74, stab, 32, throat, 2, and tires, 2. In its response, the state only refers to Detective Veely's word searches for news, body, journal, and cement, leaving out the other searches and disingenuously claiming that, quote, the mere fact that someone searched for news, body, journal, and cement doesn't show anything similar or related to this crime, unquote. The state claims that Mr. Avery gives, quote, no explanation of how any of the search terms are related to an individual's motive for this murder, unquote. However, the state chooses these few cherry picked words and ignores the rest to minimize the importance of the word searches. Taking these terms in the context of Ms. Halbach's murder and its potential motive, all these terms are relevant. 2 bullets from a gun pierced her skull. There was a fire ignited by gas and tires, which burned her body. She may have been handcuffed. She bled in her vehicle, so she may have been stabbed. Her DNA was found on a bullet, and she did keep a journal. So I'm talking really fast, Donna. Blah, 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 blah. Okay. Timing of searches. Oh, where is that footnote? Holy cow, because that's a long one at the bottom here. In its response, the state concedes that Bobby is at least connected to 3 of the most violent searches prior to Ms. Halbach's murder, but the state has inadvertently conceded that Bobby is connected to 25 of the searches after Ms. Halbach's murder. More importantly, Bobby cannot be eliminated by the state from any of the pornographic searches, especially the ones conducted prior to and very close in time to Ms. Halbach's murder. The individual performing the searches was becoming obsessively deviant in the weeks before Ms. Halbach's murder. Footnote on there is talking about other cases, so we skip that. The state fails to consider that the motive for this crime started as a sexual assault that turned into a murder. So all the pornographic images are relevant. Let me put, okay. So y'all who've been following me know once upon a time, I used to visit Stephen. That was second visit. Because first visit, I wore my Free Melissa shirt. So this was the first visit I had with Steven. Okay. And I only visited him, I think 3 times total. Um, and no, I don't speak to him any longer. I don't have any issues with Steven. Steven's got the issues with me, which is fine. Still doesn't change, I believe in his innocence and I'm fighting for his freedom. So that's funny, Donna. I've told this story before, and it's also here I am going to be gross in my book, Wrongfully Abused, available on Amazon. I put it in my book too because this is a big deal. So when I was visiting Stephen, this girl, now Stephen and I are not sitting on an aisle. We're kind of like in the middle and like 2 or 3 rows in from the end. And the girl walks behind Stephen as she's walking to wherever her assigned table is to sit for the guy that she's visiting. And so she walks right behind Steven and she says, um, "How you doing, Steven?" And Steven said whatever it was. He said, not doing well or whatever. And she kept walking. It was just a quick exchange. And then Steven said to me, "Do you know who that was?" And I'm like, "No, I have no idea." It was one of Teresa Halbach's sisters. She was there because her boyfriend at that time was in the prison. So I found it very interesting. Why would she purposely go right behind Steven to get to where she was going if she thinks Steven is this killer? Why would she make that killed her sister? Why would she make any kind of small talk with him? Because where she was seated, her table was on the completely other side. She wouldn't have to go anywhere near Steven, but yet she walked directly behind him and then even said to him, Steven didn't say anything to her. She said, "How are you doing, Steven?" I find that very important. Um, and I don't know what reminded me of that, of why I wanted to say that, but that's such a big thing. Um, okay. Now I got to go back to where I was reading. Right, Donna? So I don't think all the family thinks um Steven did it. And Steven said that's not the first time he's talked to her either. Um, all right. Let me go back. All right. The state fails to consider that the motive for this crime started as a sexual assault that turned into a murder. So all the pornographic images are relevant. All the evidence appears to point to Bobby conducting the searches in question on weekdays, but it is necessary to have an evidentiary hearing to definitively determine if it was him. Based upon the findings of Mr. Gary Hunt, Mr. Avery's forensic computer expert, 667 sexual content searches were performed in total. Of those searches, 562 were performed on 10 weekdays between 6 a.m. and 3:30 p.m. On August 16, 2005, there were 4 searches. On September 13, 2005, there were 12 searches. On February 23, 2005, there were 48 searches. Oh, wait, that's actually what I was going to tell you, too. Let me put my mouse there. So, another thing that Steven told me on the visits, that's probably what I meant to tell you and not the other thing, is that, and I don't think he told me on a visit. I think he told me on a phone call that, okay, so how many times had Teresa been there to take pictures. It was like 3 times previously, right? And so he told me that Bobby always knew when Teresa was coming and would always remark to Steven about her being there. And when is she getting there? And he would refer to her. Steven had said that Bobby would say Steven's girlfriend. Your girlfriend's coming today. When's your girlfriend coming? So he was always aware of all those other times that Teresa Halbach had been there. So that's where you're seeing then that this obsession is starting. Right, Mary. Teresa didn't have an issue with Steven. If she did, and if she was afraid, she knew, even in this case when it's saying B Yonda, but you see the address, Avery Road. You know what that is. So she didn't have to go. Another photographer could have gone if she had had some incident with him that made her uncomfortable, or she could have had somebody go with her. She was fine with him. All right. Back to where we were. March 29, 2006, 37 searches. March 30, 2006, 23 searches. April 3, 93 searches. April 5th, 96 searches. April 6th, 14 searches. April 13, 39 searches. April 19, 196 searches. Yeah, she gave her cell phone number. Absolutely, Mary, because she wanted to make the double the money by a hustle shot. I don't blame her for that at all. Therefore, 64 sexual content searches were performed prior to Ms. Halbach's murder between 6 a.m. and 3:45 p.m. when Bobby was supposedly at home alone. Another 500 searches were performed in the same time frame after the murder when Bobby was supposedly home alone. Let me mark it here. Also, all the boys knew, everybody knew that Teresa Halbach was coming that day, or that the picture girl was coming to take pictures that day, because Barb told her boys they had to clean out the van. And then the boys were pissed because they just wanted their mom to give them that vehicle. They didn't want her to sell it. So they knew. So Bobby knew ahead of time that Teresa Halbach was coming to the salvage yard that day. Um, Egypt says, who was it that came up? Teresa being uncomfortable that Steven supposedly opened the door wearing nothing but a towel. I believe that was somebody from Auto Trader that said that. And I firmly believe, and I don't remember after all this time if this is something that's been said or something that now I've just come up with the explanation for, is that Steven had a pool. He was wearing a towel around his waist because he had been in the pool when she knocked on the door. He wasn't naked. You know, So, and maybe a joke had been made about the towel around him or whatever. Some stupid, dad joke or kind of pervy joke could have even been when Teresa Halbach was there. Um, but there was nothing that made her uncomfortable that she wouldn't go back. Correct, Mary. Just got out of the pool. All right. The state has focused on a subset of 128 searches that Mr. Hunt identified, which comprised very specific image searches focused on pain, torture, humiliation, and death inflicted upon women. Bobby cannot be definitively excluded from the following 128 most violent searches. A. 22 search terms describing forcing sex toys and objects into vaginas. B. 28 searches for terms describing violent accidents, specifically violent car crashes with images of dead bodies. C. Oh boy, it continues on the next page. C. 13 searches for terms describing drowned, dead, or diseased female bodies, and D, 65 searches for terms describing the infliction of violence on females, including fisting and images of females in pain. They were so desperate to find some kind of porn at Stevens to be his motive. And again, they know all this is on Bobby Dassey's, who's right next door, who claims he saw her that day. They have it all right there, gift wrapped for them. But they're so desperate because of that 36 million. We don't care who really did it. We just need to get rid of that 36 million. So who knows who all else Bobby has harmed? And he has children now. I fear for those kids. Um, sorry, Egypt. Um, the state links Bobby to 28 of these searches during the day and argues that only 3 of those 28 are relevant because they occurred before Ms. Halbach's murder. However, the state totally misses the point that all 677 sexual searches are relevant to a sexual assault motive, which would exist before the crime and be corroborated after the crime by a continuing obsessive pornography consumption. Mr. Avery has provided sufficient evidence concerning the schedules of the occupants of the Dassey residence to justify an evidentiary hearing on the issue of who was conducting the searches. Mr. Avery has provided additional evidence from that provided in his appeal about the schedule of the occupants of the Dassey residence, showing that the pornographic searches primarily occurred on weekdays when Bobby was sought to be in the residence. To make this determination, an evidentiary hearing must be held. Stated differently, in the absence of an evidentiary hearing, it's impossible to make this determination. The schedules of the other Dassey household members seem to eliminate them from the searches cited above. Barb's work schedule was from 6 a.m. until 4:30 p.m. every day, Monday through Thursday of every week. Now we're on page 16 or 17 of 46. Brendan and Blaine would get picked up by the school bus at Avery Road between 7:08 a.m. and 7:13 a.m. and dropped off at the same place between 3:30 p.m. and 4 p.m. Therefore, it appears that Barb, Blaine, and Brendan, the 3 other individuals living at the Dassey residence, are excluded from being present, much less having access to the Dassey computer at the times many of the pornographic searches occurred. Additionally, Brendan would be eliminated from all but 26 of the 128 of the most violent searches related to Ms. Halbach's murder, which is 20.3%, by having been arrested on March 1, 2006. It is undisputed that Mr. Avery never accessed the Dassey computer. He did not have the password for the computer, nor did he possess a key to the Dassey residence, which was locked when no one was home. Mr. Avery only entered the residence with the permission of Dassey family members. Mr. Avery worked during the weekdays from 8 to 5 p.m. Mr. Avery would be eliminated from all but 15 of the 128 of the most violent searches related to Ms. Halbach's murder, which is 11.7%, simply by having been arrested on November 9, 2005. Very true, Mary. And hello, Alan. Next section is searches that took place after Ms. Halbach's murder. The state argues, quote, Avery fails to explain how motive to fulfill a violent porn-fueled sexual fantasy can be formed or proven by someone not viewing any of this material until months after the murder already occurred, unquote. However, conduct of a suspected person after the crime is a legitimate subject for consideration as bearing upon the probability of his guilt. Motive can manifest itself after the crime when the perpetrator is reliving and fantasizing about the crime. The continued searches for pornography demonstrate that the motive for this murder was a sexual assault. It is highly significant that the searches for deceased, mutilated young women began after italicized, not before the murder and mutilation of Ms. Halbach. The searches after the murder coincide with the fact that a young woman was murdered and mutilated. The searches before the murder coincide with thousands of images of young women engaging in sexual activity, many unwillingly, and corroborate a sexual assault motive. Next section's titled The Dassey Computer Deletions, a Consciousness of Guilt Inference. The state completely ignores the evidence presented by Mr. Avery of the Dassey computer deletions, which infers consciousness of guilt. Significantly, many of the Dassey computer searches had been deleted, and only some of those were recovered, which leads to the question of who in the Dassey household deleted the searches and why were these searches deleted before Mr. Avery's trial. To make a complete and thorough record of who made the searches, why those searches were made, and who deleted specific searches, there must be an evidentiary hearing that consists of the testimony from the occupants of the Dassey household who can answer these questions for the court. It is not possible for this court to determine, without an evidentiary hearing, who conducted the searches of the pornography and who attempted to delete the pornography after the murder of Ms. Halbach and before the trial of Mr. Avery. It is highly significant in any investigation if there is an attempt to delete or destroy records. And then it's citing another case. Mr. Hunt has identified 8 times when there were deletions on the Dassey computer. Those deletions are very important because they correlate with Ms. Halbach's visits to the property. Ms. Halbach visited the property on August 22nd, 2005, and there are deletions on the Dassey computer from August 23rd through August 26th. Ms. Halbach visited the property on August 29th, 2005, and there are deletions from August 28th through September 11th. Ms. Halbach visited the property on September 19th, and there are deletions from September 14th through September 15th. Okay, so all right, so I was right. 3 other times she was there before Halloween. There are also deletions from September 24 through October 24. Most significantly, around the time of her murder on October 31, there were deletions from October 26th to November 2nd. During the investigation of Ms. Halbach's murder, beginning November 3rd, there were further deletions made on the Dassey computer. These deletions, as the above described relevant times, cannot simply be dismissed as mere coincidences, and an evidentiary hearing needs to be held to determine who made these deletions and why. Dr. Burgess wrote in her affidavit, quote, "It is not unusual for an organized offender to try to cover up his fantasies by deleting files from a computer," unquote. She agreed with Mr. McCrary that it is, quote, "highly significant in any investigation if there is an attempt to delete and destroy records," unquote. Dr. Burgess concluded the following, quote, "The offender in the Halbach murder would be classified as an organized offender who plans, thinks things through, and now this is in bold, tries to cover his tracks by deleting incriminating files, injecting himself into the investigation as a primary witness for the state, misleading the investigators about the timeline and events surrounding the murder, and would be very likely to attempt to plant evidence and frame another for the murder. The offender would keep his secret his commission of the sadistic murder of Ms. Halbach," unquote. All right, now this is citing another case, blah, blah, blah. Opportunity was established by the simple fact that The victim visited the defendant's neighborhood. Here, Bobby's possession of the victim's vehicle is much more powerful evidence of a direct connection to the murder and the opportunity to plant all the forensic evidence to frame Mr. Avery. The burden of establishing motive based on the Dassey computer evidence is greatly lessened by establishing Bobby's direct connection to the crime and opportunity to have committed the murder and planted the evidence to frame Mr. Avery. The state argues that Bobby's searches did not reveal things closely mirroring the crime, contending, quote, Avery fails to point to a single image or search for someone who is shot and the body burned, nor anything that would suggest that these widely varying types of pornography had any similarity whatsoever to Ms. Halbach's murder, and has included such irrelevant off point searches such as MySpace, tires, race car accidents, Ford Focus accident, diseased girls, and big woman naked, unquote. The state is wrong. Mr. Avery did, in fact, provide this court with specific searches about, quote, someone who is shot, unquote, and searches for a, quote, gun to head, unquote. There were 8 searches prior to Ms. Halbach's murder on 9/17/05 for skeleton and alive skeleton. Alive skeleton. Okay. These searches exactly mirror Ms. Halbach's fate. In any regard, the state misconstrues the holding in, okay, going back to the other case, blah, 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 blah. Um, okay. Likewise, here, most of the Dassey computer pornography consists of images depicting violence, even race car accidents, that show a fascination with death and mutilation. And this trait is italicized, of the Dassey pornographic consumer is, quote, undeniably probative of a motive, intent, or plan to commit a vicious murder, unquote. Moreover, each piece of a defendant's proffered evidence need not individually satisfy all 3 prongs of the Denny test. Some evidence provides the foundation of other evidence for other evidence. Facts give meaning to other facts, and certain pieces of evidence become significant only in the aggregate upon the proffer of other evidence. Additionally, strong evidence implicating the third party on one prong may lessen the need for evidence on the other 2 prongs. The strong new evidence of Bobby's direct connection and opportunity to murder Ms. Halbach by virtue of having possession of her vehicle after her disappearance lessens the importance of the motive evidence. Nevertheless, the VLCD of pornographic images and searches on the Dassey computer, when viewed in light of Bobby's possession of Ms. Halbach's vehicle, takes on a whole new meaning and has much more relevancy in terms of establishing the motive prong of the Denny criteria that it would stand alone. Next section is called the state's opportunity argument. According to the trial court, Mr. Avery's trial defense counsel already established that Bobby had the opportunity to commit the murder of Ms. Halbach by his mere presence. Dog's making weird noises. Oh, my husband saw. At the Avery salvage yard on October 31, 2005. Now the state wants to place an additional burden on Mr. Avery, relying on Kansas and not Wisconsin law. The state admits that under Wisconsin law, quote, opportunity can be established by simply showing the third party was at the crime scene, unquote. However, the state contends that in order to meet the opportunity prong, Mr. Avery has to offer evidence that the alleged third party perpetrator had, quote, the skills, contacts, tools, time, and or other means necessary to have committed the crime and staged the scene in the manner the defendant alleges, unquote. Quoting the Kreider opinion from another case. There is no requirement in Wisconsin law which states in much more general terms that it is sufficient to demonstrate, quote, evidence that the third party had the realistic ability to engineer such a scenario, unquote. The state concludes that Mr. Avery's submissions do not meet the Kansas standard. Since Mr. Avery's case is pending in Wisconsin, he is focused on his submissions meeting the Wisconsin standard, which he has clearly established. The state is baffled as to, quote, why is italicized, why Bobby would want to frame Avery, unquote. The answer is simple. If Mr. Avery was not prosecuted for Ms. Halbach's murder, then Bobby was the next most likely candidate to be prosecuted for her murder. He was present and observing Ms. Halbach during her visit to the Avery property on October 31, 2005. Bobby lied about being asleep from 6:30 a.m. to 2:30 p.m. Searches were made on the Dassey computer at 7 a.m., 9:33, 10:09, 1:08 p.m., and 1:51 p.m. prior to Ms. Halbach's arrival at the Avery salvage yard. Legal shade thrown. I agree. Bobby was the only one home during these searches, according to his trial testimony. Bobby was present and awake when Ms. Halbach called and left a voicemail requesting the exact address for the appointment. He was present when Ms. Halbach arrived. He lied about Ms. Halbach walking towards Mr. Avery's trailer because he saw her leave the property at the same time he left the property. He lied about going hunting and passing Scott Toddock at 3 p.m. going east in his Blazer when he was seen at 3:30 p.m. driving an unknown vehicle west by his brother Blaine and a propane driver on the Avery property, which resembled Ms. Halbach's vehicle. Ms. Halbach's RAV4 was seen by witnesses parked at the turnaround about a 1.8 miles west from the Avery salvage yard in the direction Blaine saw Bobby driving. Bobby had human is italicized, human fingernail scratches. I was going to talk about this earlier on his back that he claimed were from his puppy. Because let's not forget, he's got scratches on his back. Bobby gave false testimony about Mr. Avery's alleged remark about disposing of a body. This remark was completely discredited and contradicted by Michael Osmondson. Combined reports, re-interviews of Bobby were where Bobby never told this to law enforcement. Ms. Halbach's fuel-stained, cut large bones were found in the Dassey burn barrel, including a scapula, portions of a spinal column, metacarpals, and fragments of long bones. The state argues that, quote, Avery's defense theory has changed dramatically since the trial, unquote. Bryce, okay, let me read. And didn't Teresa call and leave a message stating what time she'd be there? I can't remember what number, but likely Bobby heard the messages, which drove him to action. Right. So he's getting an idea of what time she's going to be there, that he can be ready. I honestly think he hit on her. I don't think it started out as a sexual attack. I think he tried flirting with her and she brushed him off. And then he got angry. That's what I believe happened there. Um okay, where I have to go back to where fingernail or human fingernails. Where is that? Uh, 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 where was I? Oh, I'm just gonna okay. However, the state fails to acknowledge that because the trial court barred introduction of third-party Denny suspect evidence in Mr. Avery's trial, obviously prior to the discovery of the violent searches and the Sawinski evidence, Mr. Avery's trial defense counsel did not have the ability to suggest that persons other than law enforcement officers had access to bloody bandages, bloody towels, and blood drips that came from Mr. Avery's pre-existing finger injury. In its response, the state claims that, quote, Avery offers no reason why Bobby would want to send Avery to prison, unquote, and gives its own wild hypothesis about the impossibility of actions Bobby actions to hide the crime. The state claims, quote, nor has Avery explained why someone who wanted to frame him would go to such lengths to hide the evidence. Yes. I am on page 24 of 46. So, yeah. Why? What are you doing? What's that? Oh, yeah. I've been reading for an hour. I'll probably be at least another hour. Okay. Sorry, real life interrupts. Where was I? Uh, okay. The state claims, quote, nor has Avery explained why someone who wanted to frame him would go to such lengths to hide the evidence. Surely, if Bobby or anyone else wanted to frame Avery, they wouldn't have gone out of their way to make all the evidence difficult for law enforcement to detect, gather, and connect to Avery, unquote. The state claims that by hiding the RAV4 on the Avery property, it led the authorities right to Dassey's door. The state's assertion is demonstrably false. Putting the RAV4 on the Avery property with Mr. Avery's blood in it led the police directly to Mr. Avery's door. The RAV4 was not carefully hidden because the civilian searcher found it in less than 35 minutes among hundreds of salvage cars. We have that video here somewhere. I don't know where it is, where my husband and I walked the Pam Sturm of God path and we timed it. And there is no way possible she could have found that car in that time frame without being told where to go. Period, point blank. Not possible. Um, It makes perfect sense, contrary to the state's argument, to burn the victim's remains and personal property and plant them in Mr. Avery's burn pit to frame him. Mr. Avery was the only one who had a huge civil rights case pending against the Manitowoc County Police, so he became law enforcement's target of choice. The police needed Bobby to testify against Mr. Avery to say Ms. Hawbuck went to Mr. Avery's trailer, and Bobby needed to testify to exculpate himself and inculpate Mr. Avery. Bobby seized every opportunity to frame Mr. Avery, including becoming the state's star witness. All right, let me pause there. We talked about this in the almost 3-hour video I did this morning of reading the filing that Kathleen made yesterday of and maybe I'll make you not go into it all, and you're just gonna have to go there to see everything I said on that. Um, but the family didn't like Steven. The family wanted Steven gone, and the family wanted his $36 million. So, to me, it makes sense if you wanna say that Bobby at first is taking everything away, getting rid of everything off the property, you know, because I don't think initially it's, "Oh, I'm gonna frame Uncle Steve." I think that's why days later, you're pushing the car back to the salvage yard. Why would you bring it back when you had it somewhere else that you're then not linked to? Same thing with the bones. I think he grabbed his burn barrel, and now it's that we're framing Steven, we're gonna throw this stuff in Steven's burn pit and Steven's burn barrel. So, I don't think that, um, Bobby started out with, "I'm going to frame Uncle Steven." I think it's something that after a couple of days and discussing it with Scott Todek, Mike Osmondson, um, came up with, "Let's go after Steven. We don't like him. We want him gone, and the family will get the $36 million, and Bobby will get a piece of that." That makes perfect sense to me. All right. The state is incorrect that the evidence was difficult for law enforcement to detect, gather, and connect to Mr. Avery. The evidence was blatantly easy for law enforcement to detect immediately after is italicized, it was planted, such as when Ms. Halbach's RAV4 was suddenly found coincidentally at the Avery salvage yard after witnesses observed the vehicle in a different location earlier in the week. Or Mr. Avery's blood was found selectively dripped in the RAV4 and placed on the dash with an applicator. Because your finger's not going to make that S looking squiggly mark. And I still don't know how your middle finger here, cut here, when you're turning the keys, that finger is going to hit. And how does that finger hit the dash? How many inches away is the dash from where the ignition is that your finger's going to hit that? Not happening. It was done with a Q-tip or cotton swab if you're not using a brand name. The state is incorrect that the evidence. Oh, I read that already. Or no. All right. Select. Okay. There we go. This is where we are. I didn't move my thing. Q-tip, in my opinion. Yeah, I always call it a Q-tip. A tissue is a Kleenex. I know. None of Mr. Avery's fingerprints were found on the RAV4. Even though Mr. Avery could have crushed the vehicle in minutes, he allegedly left it in plain sight for several days with the incriminating evidence intact. Let me try and mark my spot. Not only did he park the car there, he double parked it so it sticks out like a sore dick. Um and it's go oh so he double parked it so it's sticking out. It's going the opposite direction from the other cars in that row. And to you and I, a salvage yard may just seem like junk everywhere with no rhyme or reason. There was. The Avery brothers had these cars go here, these kinds of cars go here, newer cars go here. So where the RAV4 was is not where it would have been parked had it been one of their vehicles. So you're making that stand out. Then you throw the couple of things on top of it. Nothing else is on top of any other cars to continue to make that one car stick out. People were regularly all over in that salvage yard driving their golf carts around, shooting at shit. So you can't think, oh, I'm putting it all the way here back in this corner behind the pond where there's also trees. Um, nobody's ever going to see it. They're regularly driving around in golf carts. And the car crusher wasn't far from there, from that spot. And yeah, Donna, blood but no fingerprints. They want to go back and forth. Well, there's no fingerprints because he had gloves on. But then how is there blood if he's got gloves on? Can't have it both ways. Only Bobby stayed behind when others living on the property went to the family residence in Crivets the weekend after Ms. Halbach's disappearance. We talked about that this morning. Thus, Bobby had an easy opportunity to plant evidence against Mr. Avery. Ms. Halbach's key magically appeared in Mr. Avery's trailer after multiple searches had been made of his trailer without the key being detected. This bedroom I'm in right now is bigger than Steven's bedroom at that trailer. And if there was a key in this room, and I got a lot of junk in this room because this is all my books, all my little stupid things like my Smurf. um, I got lots of little figures and stuff. I've got lots of junk here. It would still be easy for you to find a key in there. But after these multiple searches by professionals, they find it. Oh, yeah. Okay. Mm, 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 mm. Thus, Bobby had an easy opportunity to plant evidence against Mr. Avery. I already read that part. All right. The state's response is completely devoid of any mention of its theory during Mr. Avery's trial. The state's theory of what happened the day of Ms. Haubach's murder left many questions unanswered. The state claimed that Mr. Avery inexplicably placed Ms. Haubach's body in the rear cargo area of her RAV4 in his garage, then removed her from the RAV4, laid her on the garage floor, and shot her in the left side and back of her head. The state's nonsensical theory was contrived to explain the presence of Ms. Haubach's blood on the rear cargo door in the rear cargo area of her vehicle. And it never made any sense to me on okay, because the state's theory is that she never left. So, and now remember in Steven's case, there's no Brendan. So he's doing what to her? How is he getting her in the garage? Remember, on a weekday, on Halloween at a working business. Um, how and so then he's putting her in the back of his vehicle, and his vehicle's not parked in the garage. The garage had a car in there and other stuff. He didn't park in the garage. Um, so he's putting her body in her car that wouldn't be parked in the garage because there's stuff in the garage, but then pulling her out to putting her on the garage to shoot her and then putting her in the car and then taking her out of the car again to go burn her in the burn pit. I don't none of it makes any sense. The state did not have an explanation for how Ms. Halbach's bones were found in multiple locations, which undoubtedly explained why Mr. Avery was acquitted of the mutilation charge. The more likely chain of events was that Ms. Halbach had finished photographing Barb Yanda's van, and she was leaving the Avery salvage yard. Bobby followed her, flagged her down, and then attacked her. He placed her body in the back of the RAV4, drove back to the Avery salvage yard, drove into his garage, shot her in the head, dismembered her body, placed her body in one of the Dassey burn barrels, and transported it to the quarry where he burned it, inadvertently spilling bones on the ground. And then he brought the bones back to the Avery salvage yard and tipped them into Mr. Avery's burn pit. The theory that Bobby returned to the Avery salvage yard with Ms. Halbach in the cargo area of her vehicle is corroborated by the fact that the propane driver saw a vehicle similar to Ms. Halbach's drive past him exiting the Avery salvage yard, and Blaine saw Bobby driving a greenish, bluish colored vehicle on State Highway 147 in the opposite direction Bobby testified he was driving, and also cell towers. Um, both witnesses making these observations at around 3:30 p.m. on October 31, 2005. The RAV4 was dumped about 1.8 miles west of the Avery property where Kevin Romlow spotted it on November 3rd. The state argues that, quote, Avery has offered no facts at all that would establish how Bobby Dassey, an 18-year-old high school graduate with no criminal record whatsoever, and who was working third shift at a furniture factory, unquote, could have executed the state's list of events that it argues had occurred in the murder of Ms. Halbach. Oh, there's a footnote. Contrary to the state's implication that Bobby being 18 years old makes him less likely to have committed the crime against Ms. Halbach, the Department of Justice has data stating that from 1980 to 2008, quote, approximately a third, 34%, of murder victims and almost half of the offenders were under age 25. For both victims and offenders, the rate per 100,000 peaked in the 18 to 25 year old age group and 17.1 victims per 100,000 and 29.3 offenders per 100,000, unquote. Back up. The state has offered no facts to establish how Mr. Avery, a high school dropout whose experience consisted of serving 18 years in prison for a crime he did not commit, suddenly decided to murder Ms. Halbach and forego the millions of dollars he stood to obtain from the state and his civil rights lawsuit. Even if a court is disinclined to believe evidence offered by a movant, the court must hold a hearing before making credibility determinations. Um, Only after an evidentiary hearing is the court charged with determining the issues and making findings of fact and conclusions of law. The state claims that Mr. Avery has the burden of demonstrating the following points, which is contrary to Wisconsin case law. But regardless, Mr. Avery responds to each of the state's allegations concerning its claim that, quote, Avery had offered no facts at all that would establish how is italicized, Bobby Dassey, an 18-year-old high school graduate with no criminal record whatsoever, and who was working third shift at a furniture factory, unquote, as follows. State's response, quote, 1. Managed to steal at some unidentified time prior to October 31 the rifle hanging above Avery's bed with which the victim was shot, and at some other unidentified time between November 5 managed to replace it with Avery's never noticing, unquote. Mr. Avery's reply. The bullets from Mr. Avery's garage and the surrounding property were the result of target shooting around Mr. Avery's garage over a long period of time. All these bullets would have matched Mr. Avery's rifle. The bullet with Ms. Halbach's DNA on it was planted by the killer. The bullet had a substance similar to red paint, like the red paint on Avery's garage, and never went through the skull or any other part of Ms. Halbach's skeleton. The killer had access to Ms. Halbach's DNA and could have easily planted it on the bullet in Avery's garage. State's response number 2, quote, could have abducted and killed the victim and hidden both her body and her car in some unknown area in the minutes between her arrival on the property and Scott Toddock passing Bobby Dassey on the highway around 3 p.m. on October 31, 2005. Nor has Avery provided any facts to establish where the killing could have happened apart from a nondescript, quote, in the RAV4, unquote, or where Bobby could have hidden the RAV4 and the victim's remains in this short period of time. Closing quote. Correct, Donna. Yeah, it went through the wall. KZ showed us that. Okay, see ya, Egypt. Mr. Avery's reply. Mr. Avery would challenge the credibility of Mr. Toddock and his timeline at an evidentiary hearing. Mr. Toddock's testimony directly contradicts the testimony of Blaine, who saw Bobby traveling the opposite direction, west on State Highway 147 at 3:40 p.m. Mr. Toddock would be impeached on a number of other issues at an evidentiary hearing, including, but not limited to, his entire timeline for his whereabouts on October 31, 2005, and his efforts to sell. Let's not forget that too, to sell Bobby's .22 caliber rifle after the murder. Oh. Um, Something else I can tell you, before I go on to the next one is, so when I went to Barb and Scott's house to interview them for back when I was friends with them, and it was for Barb's Facebook page. So I interviewed, it was her and Scott and Pete Dassey. Um, when I was just chatting with Scott, this wasn't in, I don't think this was in the interview. And the interview is no longer available. Barb was extremely paranoid about things, and so she only let the interview stay up in her group for a day and then deleted it. So it's gone. Um, but I asked Scott about the fire that he then testified, was so high, and why did it change? And what he said to me was, just like what we see was done to Brendan, that they just don't take your answer for the answer. They kept pushing him to say that it was a big fire. So that's why he said it was a big fire, but he doesn't recall a fire at all. That's what he said to me. Take from that what you want. All right. State's response. Number 3, quote, had the scientific sophistication and knowledge necessary for it to occur to Bobby to collect, transport, and plant Avery's blood from his sink. And as Avery has completely overlooked his non blood touch DNA on the hood latch of victim's RAV4 and her keys, or how Bobby acquired the skills to do this successfully, unquote. And I'm going to have something to say, but I'm going to read Mr. Avery's reply. Bobby could easily have removed blood from Mr. Avery's sink by using a wet sponge or rag and dripping it into the RAV4, which was in his possession. He could have applied the blood smear on the dash with any type of Q-tip like object from the Avery salvage yard. The touch DNA on the hood latch was planted by the police by substituting the groin swab illegally taken from Mr. Avery for the hood latch swab taken by investigator Hawkins. Even if that theory were discounted, Bobby had access to Mr. Avery's DNA by having access to his trailer, so he could have used Mr. Avery's toothbrush to plant his DNA on the hood latch. Bobby had to touch the hood latch to disconnect the battery, and he undoubtedly wore gloves. So perhaps the idea of planting Mr. Avery's DNA came to him as a result of that activity. Perhaps his 3 searches for DNA on the Dassey computer gave him the idea. All right. And I said this earlier. There are things that I recall that I don't know if it's from research I've done in the case over all these years or um is it just my theory? I don't know. But I recall one of the lab people had Steven's Grand Am next to Teresa's vehicle in their impound garage, lab garage, wherever it is they're hiding evidence. And I thought it was said he had been in the Grand Am touching things, doing things, and then he had gone to the RAV4 and didn't change his gloves. So that's how you would get Steven DNA to the RAV4. It's not even for the the hood latch or the lift gate. Um so that makes complete sense that some dum dum didn't change his gloves when he went from the Grand Am to the RAV4. And then that would explain how it's Steven's DNA, but there's no fingerprint and there's no blood. It's because it was transferred by a lab person's gloves. So that's what I think. State's response. Number 4, quote, had a convenient stash of unidentified instruments capable of collecting and transporting liquid blood on hand or what those might have been, unquote. Mr. Avery's reply. The only instrument necessary to transport the blood would be a sponge or rag. State's response number 5, quote, planted the keys to the RAV4 in Avery's trailer unnoticed and at some unspecified time between November 3 and November 5, yet also either managed to move the RAV4 off the 40-acre property without the keys or drive it away and return on foot from wherever he supposedly took it, and then sneak into Avery's trailer again to hide the keys at some other unidentified time, once again unnoticed, unquote. I got something to say about the key, but I'm going to read Mr. Avery's reply before I get into it. Bobby had the vehicle key when he drove the RAV4 to its location at the State Highway 147 turnaround on Monday, October 31, and on Friday, November 4, when he moved it back onto the Avery salvage yard. He planted the key in Mr. Avery's bedroom after removing Ms. Halbach's DNA from it and planting Mr. Avery's DNA on it. Many items in Mr. Avery's trailer could have been the source of his DNA, including Mr. Avery's toothbrush. The key was not discovered until November 8. Bobby was alone on the property after the family left on November 4 and early on November 5 until the police blocked off access to the property when Ms. Halbach's vehicle was discovered around noon. All the family members residing on the Avery property had left and traveled to Crivets to the family residence. Hey, Kimmy. Um, the key. Again, we've talked about these things a million times over the years, but it's something that needs to be pointed out. Teresa's sister, Teresa's friend, Teresa's boss, Tom Pierce, all testified that Teresa was super paranoid about losing her keys. That's why her sister got her that lanyard to put her keys on. And her friend had testified that they had made a lanyard thing out of tape on some trip they went on. And Tom Pierce talks about her paranoia with losing the keys. So if somebody is so paranoid about losing their keys, they would not have multiple sets of key rings. So why is there only a key? Where is her fob? Where is her house key? Where is her office key? And whatever other keys she would possibly have. She wouldn't have one ring that has the key to her house on it, one ring that has her photography studio. You Where are the rest of her keys? That's how you know the key that was found is not her frickin' key. It is not the one that she used every day. It's her spare key. It's the valet key. Her keys are gone. Never been found. Also, she drives for a living, going around taking all these photographs. That key would be in her hand, out of her hand, in her hand, out of her hand constantly. Her DNA should have been on that key if this is allegedly the key that she was using. But there's none of her DNA, and there's Steven's on there, but Steven's fingerprints aren't on the car. You have to open the car door. You have to shift. No fingerprints, but it's on the key. Bullshit. All right. State's response. Number 6. Quote, found and then planted a tiny mangled bullet fragment that Bobby inexplicably knew had the victim's DNA on it underneath items in Avery's garage, or alternatively, how he shot the victim in Avery's garage on October 31, and then at another unidentified time scrubbed the scene with Avery remaining unaware. This despite Avery indisputably having been working on his Suzuki and other vehicles in and around the garage around this time. Unquote. Mr. Avery's reply. Bobby had access to Ms. Halbach's blood if he killed her and could simply put the blood on one of the dozens of bullets in and around Mr. Avery's garage. There is no proof that Ms. Halbach was shot in Mr. Avery's garage. There is no other DNA of Ms. Halbach in Mr. Avery's garage. There is no blood splatter in Mr. Avery's garage or on Mr. Avery's rifle. Well, okay, it's not Mr. Avery's rifle, it's Raleigh Johnson's rifle, but I digress. There is no evidence that the crime occurred in Mr. Avery's garage. Raleigh Johnson, it's Avery salvage yard. But the trailer that Stephen lived in belonged to Raleigh. Raleigh was friends with Al. Al sold him that property. Raleigh wanted a place to store his hunting trailer. So the garage and the trailer were Raleigh's. Almost everything in that trailer, the furniture and such and whatever stuff, all Raleigh's. Jody moved into there and brought a bed and a computer desk. Everything else was Raleigh's. The gun was Raleigh's. The Glen Warfield rifle. Um, and Raleigh testified that he would regularly go there and shoot shit with that gun. And he'd be aiming at his garage because there were varmints that were popping up over there. So who knows how many bullets or casings or shells? I don't know. You would think I would know what this stuff would be called because I'm married to a huge gun enthusiast. And we've gone over all this stuff a million times in the past. But Raleigh testified that he shot that gun all over the place. So why isn't Raleigh charged with Teresa Halbach's death? It's his gun, it's his garage, and he admits to shooting at the garage. Oh, it's also aggravating. All right. State's response number 7, quote, burned the victim's body in some undisclosed location and then moved the remains to Avery's burn pit, again, completely undetected, and did it so thoroughly as to include, quote, at least a fragment or more of almost every bone below the neck, unquote, in the entire human skeleton, along with the rivets from her jeans, nor has Avery provided any facts showing where and when this occurred, unquote. And we are on page 31 of 46, by the way. Mr. Avery's reply. Mr. Avery was acquitted of burning Ms. Halbach's body. Ms. Halbach's body was not burned in Mr. Avery's burn pit, but was burned in the Dassey burn barrel, which contained Ms. Halbach's bone fragments, which had cut marks and smelled of a flammable liquid. Only 40% of Ms. Halbach's bones were ever discovered, and her bone fragments were found in the quarry, suggesting that she was burned in the Dassey burn barrel in the quarry and transported back to the Avery salvage yard, where the bones were dumped in Mr. Avery's burn pit. State's response number 8, quote, convinced his younger brother Brendan to go along with this plan and fabricate a confession implicating himself in Avery, or why Brendan would do so, unquote. Ooh, I get really mad at the Brendan stuff. Okay, Mr. Avery's reply. It was not Bobby who coached Brendan. It was the police. Du-du-du. As Brendan's interrogation video indicates, the police fed him the entire story to frame Mr. Avery. After the state improperly alleges that Mr. Avery must address all its speculative theories, it also claims that Bobby would have needed to take action in roughly half an hour because Mr. Avery's blood would have coagulated. The state, without any expert to support this assertion, claims that Mr. Avery's blood would have coagulated in half an hour. Even so, it is Mr. Avery's theory that the RAV4 was parked 1.8 miles from the Avery salvage yard at the turnaround by the bridge at State Highway 147. Driving at 30 miles an hour, it would have taken Bobby 3 minutes and 36 seconds to reach the RAV4, which would leave 26 minutes and 24 seconds to plant Mr. Avery's blood. Additionally, Bobby could have used a water-infused sponge to collect the blood from Mr. Avery's sink, which would have slowed the coagulation process without affecting the DNA profile of Mr. Avery. The internet search for blood on the Dassey computer could have revealed that the addition of water to blood slows or stops the coagulation process. If the defense theory is that a third party framed the defendant, then the defendant might show opportunity by demonstrating the third party's access to the items supposedly used in the frame up. As stated previously, Bobby had access to all the forensic evidence and therefore had the opportunity to frame Mr. Avery. Moreover, the defendant need not establish the guilt of the third party to the level that would be necessary to sustain a conviction to introduce third party perpetrator evidence. To support the introduction of such evidence, there must be a legitimate tendency that the third person could, italicized could, have committed the crime. This court cannot determine the new evidence regarding Bobby being in possession of Ms. Halbach's car and moving it onto the Avery salvage yard in the middle of the night without holding an evidentiary hearing to determine the credibility of the new eyewitness, Sawinski. No matter what diversions the state attempts to concoct or specious arguments it raises, this issue cannot be resolved without an evidentiary hearing, which necessitates credibility findings by this court. Next section is titled The State's Direct Connection Argument. This court, quote, must determine first whether the motion on its face alleges sufficient material facts that, if true, would entitle the defendant to relief, unquote. The state, rather than accepting Mr. Avery's material facts as true, is attempting to dispute those facts with speculative theories unsupported by the record. By disputing rather than accepting Mr. Avery's facts as true, the state is conceding that Mr. Avery is entitled to an evidentiary hearing to resolve those disputes. As an example, the state concedes the necessity of an evidentiary hearing in its footnote 8 by attempting to claim that Sawinski's admissions have, quote, changed drastically, unquote. The state is attempting to perform its own credibility analysis of Sawinski, which is totally improper at the pleading stage where the allegations must be taken as true. In briefly addressing the issue of Bobby's direct connection, the state argues, quote, Sawinski's averments that he purportedly saw Bobby pushing a RAV4 on November 5, several days after Ms. Halbach's murder, do not provide a direct connection between Bobby Dassey and now italicized, perpetration of the murder, unquote. However, the corroborated evidence that Sawinski provided does precisely establish the direct connection between Bobby and Ms. Halbach's murder required by Denny. The state contends that, quote, at the most generous, the exhibits Avery has submitted could establish that Bobby was involved in the moving of the RAV4 to the location where it was eventually found, unquote. The state speculates that the reason for Bobby moving the RAV4 was to cover up the crime committed by Mr. Avery. The state's theory is totally nonsensical because Bobby was the primary witness who testified against Mr. Avery. He was not trying to help Mr. Avery, he was trying to frame him. The discovery of the RAV4 on the Avery salvage yard led to all the forensic evidence used to convict Mr. Avery. If Bobby was an accomplice, he was the worst accomplice ever in a murder case. He made a much better star witness for the prosecution, helping to convict Mr. Avery while saving himself. Talking about another crime or another case. Blah, 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 blah. Applying this rationale, the Sawinski case evidence provides the direct connection, that is, Bobby being witnessed in possession of Ms. Halbach's vehicle, to Bobby probably having committed the murder of Ms. Halbach and planting the evidence to frame Mr. Avery. The state claims, quote, it provides no link at all between Bobby and the perpetration of the actual killing. It also does nothing to establish that Avery was not the killer. Even if believed, all Sawinski's evidence would show is that perhaps Bobby was involved in trying to cover up Avery's crime, unquote. Oh, now talking about another case. Bembenek is completely in opposite to the Sawinski evidence in Mr. Avery's case. We're on page 35 of 46, by the way. The new evidence presented by Mr. Avery is not cumulative of evidence presented at Mr. Avery's trial. None of the evidence provided by Sawinski directly connecting Bobby to the actual murder of Ms. Halbach and the opportunity to plant the forensic evidence to frame Mr. Avery was known during any prior proceedings in the case. Sawinski's evidence is newly discovered, i.e., unavailable and not discoverable through reasonable diligence at the time of Mr. Avery's June 2017 motion. Sawinski's existence and information was not known or discoverable by current counsel until Sawinski contacted counsel on April 11, 2021. Additionally, the state overlooks the fact that the possession of evidence used to frame the defendant also qualifies as making someone a third party Denny suspect. The state is attempting to impose a burden previously rejected by the Wisconsin Supreme Court in the Denny decision. The state is requiring that evidence connecting a third party to the crime be substantial. Wisconsin rejected that standard in another case. The appellate court specifically directed Mr. Avery to file this motion. And now somebody just texted me, and my phone's downstairs. Damn it, I'm dumb. To file this motion pertaining to the new evidence from Sawinski, and specifically stated that the evidence needed to survive any challenge. But perplexingly, the state has waived the challenge by not raising it. Therefore, the state has conceded that challenge is not a bar to Mr. Avery's new motion. Mr. Avery has provided a sufficient reason for overcoming that bar in his third motion for post-conviction relief. Sorry, I'm reading comments right now. Okay. Mr. Avery is entitled to an evidentiary hearing on his newly discovered evidence claim. Defendants must meet a 5-part test to obtain a new trial based on newly discovered evidence. While moving for a new trial based on an allegation of newly discovered evidence, a defendant must prove 1. The evidence was discovered after conviction. 2. The defendant was not negligent in seeking the evidence. 3. The evidence is material to an issue in the case. And 4. The evidence is not merely cumulative. Now, talking about another case. If the defendant is able to prove all 4 of these criteria, then it must be determined whether a reasonable probability exists that had the jury heard the newly discovered evidence, it would have had a reasonable doubt as to the defendant's guilt. This section's titled Avery has pled facts that would sufficiently establish the 3 prongs of Denny, and Mr. Avery's allegations that Bobby was the perpetrator would be admissible in trial. As stated above, Mr. Avery has sufficiently established opportunity, motive, and a direct connection of Bobby to the crime. Next section, there is a reasonable probability of a different result at a new trial. The state argues that even if Mr. Avery has presented newly discovered evidence, at least satisfying the first prongs of the newly discovered evidence test, he cannot show that this evidence would cause a jury to have reasonable doubt of his guilt. First, the state contends that because Mr. Avery did not plead sufficient facts to establish Denny, his allegations would be inadmissible at trial, and thus he is not entitled to an evidentiary hearing on his newly discovered evidence. However, as already argued above, Mr. Avery has pled sufficient facts to establish Denny. Therefore, the state's argument fails. Second, it argues that even if the Sawinski evidence were admitted and Mr. Avery's theory of defense were presented, there is no reasonable probability of a different result at a new trial. The state claims, quote, as explained above, there are far too many irreconcilable inconsistencies between Avery's allegations about Bobby Dassey and the actual evidence produced at trial. Particularly damning would be Avery's complete failure to account for his DNA on the hood latch of the RAV4 and Ms. Halbach's remains, again, including a fragment from virtually every bone in the human body being found in his burn pit, and nothing to explain how Bobby could possibly be responsible for the bullet with Ms. Halbach's DNA on it being found in his garage and matched to the gun above his bed. Unquote. Mr. Avery addressed his DNA on the hood latch. In regard to Ms. Halbach's bone fragments in his burn pit, the state needs to be reminded that Mr. Avery was acquitted is italicized, of burning Ms. Halbach's bones in his burn pit. Additionally, as noted above, Mr. Avery's current forensic fire expert, John DeHaan, has completely refuted the state's theory that a human body was ever burned in Mr. Avery's burn pit. Mr. Avery has explained how Bobby could easily be responsible for the bullet with Ms. Halbach's DNA being planted in Mr. Avery's garage that matched his gun. Ms. Halbach's DNA in the RAV4 and the spent bullets from Mr. Avery's Raleigh Johnson's rifle in his garage and property were easily accessible to Bobby. The state claims that, quote, enormous amount of forensic evidence pointing directly to Avery as the killer were all far more material than Bobby, unquote. The state misses the mark entirely. If Bobby transforms into a viable third party Denny suspect because the Sawinski evidence is found to be credible after an evidentiary hearing, all of the forensic evidence used to convict Mr. Avery is now placed in Bobby's hands. He is no longer facing a jury as a disinterested, unimpeached witness. The state has not presented a shred of evidence that Bobby did not commit this crime, such as an alibi, particularly in light of his possession of Ms. Halbach's blood splattered vehicle directly connecting him to her actual murder, his opportunity to plant all of the forensic evidence, and the motive established by the pornographic searches on the Dassey computer located in his bedroom. Talking about another case. Mm-mm-mm. Mr. Avery would be able to present his theory that all of the evidence against him was planted and that Bobby is a viable third party suspect. There is a reasonable probability of a different result at a new trial. Section 3, Mr. Avery has pled sufficient facts to establish a violation of Brady versus Maryland. Mr. Avery provided sufficient facts to establish the audio clip's materiality. And now talking about Brady and legal blah, 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 blah. The state claims, quote, Avery's dogged insistence that Bobby Dassey, quote, was the state's primary witness against Mr. Avery at his trial, unquote, remains false no matter how many times he repeats it. Bobby established only that Ms. Halbach arrived at the Avery salvage yard on the day in question, and that he saw Ms. Halbach walking toward Avery's trailer shortly before she disappeared, unquote. Bobby was the state's primary witness against Mr. Avery. During his closing argument, Professor Kratz, once again emphasized the importance of Bobby's testimony and vouched for his credibility. Quote, we talked more about the timeline and we heard from Bobby Dassey, again in the same kind of a position to be, his credibility to be weighed by you, but is an eyewitness. Again, an eyewitness without any bias. It is a individual that deserves to be given a lot of credit because sometime between 2:30 and 2:45 he sees Teresa Halbach. He sees her taking photographs. He sees her finishing the photo shoot, and he sees her walking up towards Uncle Stephen's trailer. Unquote. Bobby's testimony was the most determinative of Mr. Avery's guilt, and the footnote for that was Bobby was one of only two witnesses whose testimony the jury requested to review during deliberations. Back up, because the state used it to establish that Ms. Halbach never left the Avery property alive. If the jury knew that Bobby was lying about seeing Ms. Halbach leave the Avery property because he was in possession of her blood spattered vehicle and moved it back onto the Avery property, then the defense could have argued that Bobby was directly connected to the actual murder of Ms. Halbach and planted the forensic evidence to frame Mr. Avery. With a viable third party Denny suspect who is directly connected to Ms. Halbach's murder and to planting the forensic evidence to convict um, Mr. Avery, confidence in the verdict would be undermined. There is more than sufficient evidence to conclude that Bobby actually committed this crime. There is no reason for him to have told the multiple lies that he has told in this case if he has no culpability. There is no reason for him to have possession of the victim's blood spattered vehicle or to have planted it on the Avery property. There is no reason for him to have unexplained scratches on his back or the victim's cut, fuel stained bones in the Dassey burn barrel. Bobby was the only family member to stay on the property after others had left. Next section, Mr. Avery's Brady claim regarding Kevin Romlow has not been litigated. The state incorrectly claims that the Brady issue regarding Romlow seeing the RAV4 was already litigated. In the appellate court's July 2021 opinion, the appellate court noted that in Mr. Avery's motion for reconsideration, he raised an issue pertaining to a witness affidavit attesting in 2005 a witness, Romlow, observed a vehicle matching a missing person poster of Halbach's car and informed law enforcement of that fact and, quote, the state withheld evidence that Halbach's vehicle was seen on the street days after her disappearance, unquote. The appellate court declined ruling on the issue and therefore it was never litigated. Specifically, the court stated the following. I got to put a pause in this. I just keep thinking about, now I said on the video earlier, I work in politics and I have several friends who just got elected um for to be judges. And one of them, she's so adorable. She bought my book and she brought it to a political event and had me autograph it for her. So cute. Um I'd really love to give her this and get her opinion on it. But see, I guess she can't really do it. That's the thing that sucks with when your friends run for judge is now once they're elected, they have to be very, they can't come out and play anymore. They have to, when they're not corrupt. I guess I should say when they're not pieces of crap judges. Um so I don't know if she would read this and just give me her opinion how she would rule as a judge. I don't know. I'm trying to think. I mean, I could text her. Um a- and I won't be seeing her in person until the end of February. But I just really want to know what she thinks of all of this and the refusal of giving an evidentiary hearing. All right, so let me go back. Specifically, the court stated the following quote, neither we nor the circuit court have squarely considered whether these claims are procedurally barred under Escalano Naranjo or whether Avery pled sufficient material facts entitling him to a hearing, although our analysis overlaps with the former inquiry. Such consideration would have to come on a separately filed motion, and we express no opinion as to whether such claims would be barred in the event such a motion is filed, unquote. Mr. Avery could not have discovered the existence of Romlow through reasonable diligence because there was no mention of him in any police report or prior defense counsel's file. It would have been impossible for Mr. Avery to discover this evidence. It was only after Mr. Avery filed his 2017 motion that this witness came forward. And let me say, too, these witnesses, all of them, not just Romlow and Sawinski. I'm talking Blaine. I'm talking Brad. Um, all these people came forward back then. I can see maybe if people were just coming forward now, why people would say, "Oh, they just want to be part of this case and be famous and or something like that." But I still think you have to do your due diligence and search it, so I'm still gonna tell y'all if you're out there, if somebody's out there who knows something about this and you've never come forward and you know something, go to KathleenTZellner.com, click on the Stephen Avery tab, and then I think it's on the left side of the page. She's got a direct email and phone number for the Stephen Avery case and tell her what you know. Um, So even if a brand new person comes forward right now with evidence, I you have it has to be looked into. You can't just dismiss it and say they just want to be famous. But all these people came forward back then and it was covered up. Okay. Where was I? All right. This is where I am. And we are now on page 41 of 46. So we're almost done here unless I start ranting about something. Next section's titled, "The record does not conclusively demonstrate that Avery could not establish a Brady violation at a hearing." The state claims, quote, "Even if Mr. Avery's Brady claim regarding Romlow were not previously litigated, it would fail because the record conclusively demonstrates that what Romlow says in his affidavit about telling Sergeant Andrew Colborn on November 4 that he saw the victim's RAV4 on a highway cannot possibly be true," unquote. The state proceeds to dispute Colborn's schedule, which is an improper attempt to litigate a witness's, and there's a footnote. Is there a footnote? Guess not. I guess it's just an apostrophe that kind of looks like a footnote. Litigate a witness's credibility in the pleadings. Romlow's credibility must be the subject of an evidentiary hearing. Regarding the Sawinski evidence, the state deliberately conflates the snippet of audio that Mr. Avery discovered with the information that Mr. Sawinski provided to police that is the basis of his Brady claim. Mr. Avery does not have to present any audio, including a snippet of audio, to allege his Brady violation. In fact, the significance of the audio is that it corroborates the fact that Sawinski provided exculpatory information in the Manitowoc Sheriff's Department that was suppressed by the state. Sawinski could simply testify he reported this occurrence to law enforcement, and if this court finds him credible, it is sufficient to establish a Brady violation. The state's claim that the audio clip transcript undermines the veracity of Mr. Avery's claim is nonsensical because the court can listen to the audio clip without looking at the translation provided by Mr. Avery. The audio clip from the Manitowoc Sheriff's Office speaks for itself, literally speaks. Further, in regard to footnote 10 of the state's response, Mr. Avery is not obligated to have an affidavit from Sergeant Senglob or any investigator at the Manitowoc Sheriff's Office who spoke to Sawinski on the phone. It is sufficient that Sawinski would testify that he made the call to the Manitowoc Sheriff's Office, and it is up to this court to determine his credibility. The audio clip simply provides some corroboration of Sawinski's witness affidavit. Next section. Mr. Avery has satisfied the Allen requirements for an evidentiary hearing. And blah, blah, blah stuff on that. So it's the who, what, where, when, why, and how. So newly discovered evidence, Sawinski evidence for Brady violation. Who? Thomas Sawinski, the witness who observed Bobby Dassey pushing Ms. Halbach's vehicle. What? Sawinski was delivering papers on the Avery salvage yard in the early morning hours of Saturday, November 5, 2005. He observed Bobby Dassey with an unidentified male with pushing Ms. Halbach's vehicle down Avery Road on the right side towards the salvage yard. Sawinski reported this to the Manitowoc Sheriff's Office. The Manitowoc Sheriff's Office and prosecutors failed to disclose this information to Mr. Avery's trial attorneys. Where? The Avery salvage yard. When? The early morning hours of November 5, 2005, the same day Ms. Halbach's vehicle was discovered by law enforcement after civilian searchers discovered the vehicle on the Avery salvage yard. Why and how? This new evidence disclosed to Mr. Avery directly connects Bobby Dassey to the actual murder of Ms. Halbach, as well as having the opportunity to murder Ms. Halbach and plant the forensic evidence used to convict Mr. Avery. This new evidence, combined with the previous motive evidence, establishes Bobby as a third-party Denny suspect. As with any other civil pleading, in assessing the legal sufficiency of the motion, the court must assume the facts alleged therein to be true. And now talking about another case. Conclusion. Mr. Avery respectfully requests that this court grant him one of the following alternate remedies. 1. Grant an evidentiary hearing. 2. Grant his amended motion for post-conviction relief by ordering a new trial. And 3. Grant the requested relief and grant any and all relief this court deems appropriate. Dated this 26th day of January, 2023. And then Exhibit A is a CD-ROM disc. That written on there says Exhibit A, violent pornography. And I can't read all the words because it's just a picture of the CD. And then that's it. Took us a little over 2 hours to read that. I don't know what happens now. I don't know if the state gets to respond to this or if now we've got 30 to 60 days for the judge to respond, or if the judge has as long as they want. I never remember cuz I'm not the one who pretends to be a lawyer. I'm not a lawyer. I rely on Kathleen Zellner. She's the lawyer. Um so I'll try and get it figured out by, somebody who actually knows what the actual next step is, what we're waiting for next, and we'll get that posted. Thank you, Yasta. Um we'll get it posted on our Stephen Avery Project Facebook page. If you're somebody who knows, you can let me know. You can always email me at either I've got official Stephen Avery Project at gmail.com, as well as there's a Justice with Jax at gmail.com. So if you're a lawyer or a judge or whatever, and you know what the next steps are and you want to shoot me a message and let me know so I can inform everybody else. My husband just got home again. So whenever something else comes out, we'll go live and read it. Do another plug for my book, Wrongfully Abused, Making an Advocate for Stephen Avery, is available on Amazon in hardcover and paperback and ebook. And so those books are about my experience on being somebody's searching this case and advocating for Stephen. So if you're interested in that book, the next time I'll probably be doing some kind of live is another one of the cases that I'm on, the Marnie Yang case. We go to court on Monday. So if anything substantial happens I don't have to go actually to court. We're just on Zoom. Um, but if so that'll probably be the next thing that the that I would be doing a live for is the Marnie Yang case. Um, unless something blows up in Steven's case, um, I don't know for sure when I'm next going live to talk about his case. But thank you everybody for joining me for the 2 hours. We just went over that. And those of you who are also on the one I did earlier today that was almost 3 hours long, on our playlist in here, there's tons of other videos that I've done over the years when we've gone to Manitowoc, and all of that is in there, as well as we've done live videos on Stephen Avery Project on Facebook, and we've done it in our closed group that's called MAM Gossip, where that's where we get more into the insider crap that happens. And Mary is pointing out you need to thumbs up and subscribe to this. So maybe you'll get a notification next time I go live. So, all right. I'm going to go and I'm going to change into pajamas and talk to my husband about dinner. And um and then when I'm able to, I don't know how I can make this so you all can read it. Maybe cuz I'm not technical like that. This was, and now I'm gonna sound like a douchebag, Kathleen Zellner emailed this to me. So it's not uploaded somewhere that I can just share this link for people to read it for themselves. So, um, maybe by tomorrow somebody else will have posted it and we'll be able to just share that. I don't know. Or I can have my husband, because he will know how to do that. And make it so it's hosted somewhere and I can share it and people can read it. And so that would get posted on Stephen Avery Project, the public page. So look for that either late tonight if my husband wants to do it tonight or tomorrow. All right. So always remember, we will fight until Stephen and Brendan are free. They are both innocent, period. And on any page I run, whether it is Facebook or here on YouTube, I do not entertain any discussion of guilt. There are different pages for that you can go to if you want to debate that stuff. I know the facts show that both Stephen and Brendan are innocent, period. So have a nice night, everybody, and we will talk again soon. Investigation continues.